Sponsoring your spouse or common law partner for immigration to Canada? I'm going to help you choose inland or outland, explain timelines, and share exactly what evidence to include for a successful application. Hi, I'm Brooke. I'm the founder of Navio and a Canadian immigration expert. We help families like yours navigate complex immigration processes without the law firm price tags. In this video, I'm going to cover who can be sponsored, who can sponsor, the difference between inside and outside Canada sponsorship, timelines, travel, the evidence you need to include, how to avoid common pitfalls and mistakes, and what to do if you don't fit perfectly within IRCC's definitions. You can also visit Navio HQ. It's our totally free online portal that is full of guides, templates, and other resources to help you navigate this journey successfully. I'm going to start by diving in to the top questions asked about sponsoring spouses in Canada. First, how long does it take? It depends on the category you choose, whether you're applying in the spouse and common law partner class or in the family class. Spouse and common law partner is taking upwards of 24 months as of the recording of this video, and outside Canada varies significantly. I believe the average processing time online is 13 months, but in reality, it depends on the visa office that is processing your application and can vary anywhere from a couple months to over a year. Next question. Who is eligible to sponsor? Canadian citizens and permanent residents can sponsor eligible family members. Canadian citizens living abroad can sponsor their family members if they can demonstrate that they'll return and reside permanently in Canada when their partner receives permanent residence. Permanent residents sponsoring their family members must be residing in Canada to sponsor a family member, and the sponsor cannot be subject to a sponsorship bar. For example, a sponsor cannot have declared bankruptcy, cannot have been sponsored themselves for permanent residence in the past 5 years, and cannot be receiving social assistance other than for a disability. Is there a minimum income to sponsor? If you are sponsoring a spouse or common law partner or conjugal partner, no, there's no minimum income requirement that you must prove. However, every application for permanent residence is assessed on the sponsored person or the principal applicant's ability to financially support themselves in Canada. So it's still important to include evidence and details of how you as a couple will financially support yourself in Canada. Do I need to be married for a certain amount of time before I apply? No. You do not have to be married for a certain duration before you can be sponsored or before you can sponsor someone. And you don't have to have cohabitated or lived together for any set period of time if you are married before you can sponsor somebody. Common law partners have to have resided together for 12 consecutive months before you can be sponsored or before you can sponsor your common law partner. Regardless of whether you're married or in a common law relationship, you still have to show that your relationship is genuine. Inland or outland, what's the difference? Inland is often used to describe the spouse and common law partner class. There's also the family class. So I want to clarify that inland and outland are terms that often get used. The proper names, the official program names, are the spouse and common law partner class and the family class. The spouse and common law partner class is for couples who are residing in Canada. The family class is for couples who are residing in Canada and couples residing outside of Canada. Can also be used by couples who aren't currently cohabitating or living together, whereas the spouse and common law partner class, or commonly known as the inland or inside Canada class, requires that you be living together with your partner. How long are you responsible for your sponsored spouse? When you sponsor someone, you must sign a sponsorship undertaking, and that is essentially a commitment to providing housing, clothing, and food for the person you're sponsoring for a minimum of 3 years. You're not committed to paying for everything for this person if they are capable of supporting themselves and are working. But if at any point the person you've sponsored is unable to support themselves and provide for their basic needs, then you as the sponsor are responsible for covering the costs to provide those basic needs. Again, housing, clothing, and food. And that sponsorship undertaking persists for 3 years, regardless of whether or not the relationship breaks down. What are the costs? You have to pay fees for PR processing for the principal applicant and each dependent child included in the application, if there are any, as well as the right of permanent residence fee for the principal applicant and accompanying dependent children. There are also third-party costs, like costs for immigration medical exams and police certificates and photos. What happens if the application is refused? It depends on the class through which you apply. Generally, the family class allows appeals at the Immigration and Refugee Board, whereas the spouse and common law partner in Canada class allows appeals to federal court. What's the difference? An appeal to the federal court is typically slower and more costly. Okay, now let's dive deeper. I want to explain the difference between a spouse, a common law partner, and a conjugal partner, because those are the 3 eligible family members, partners, who can be sponsored by Canadian citizens and permanent residents. A spouse is someone to whom you're legally married. Whether that marriage took place in Canada or abroad, it's someone to whom you are married. If your marriage took place outside of Canada, it must be legally recognized in Canada. For example, Canada doesn't recognize marriages where both parties were not physically present. So if someone attended by phone or video conferencing, that is not recognized under Canadian law and would not be eligible for sponsorship as a married spouse. Common law couples are partners who have lived together for 12 consecutive months, whether that's in or outside Canada, doesn't matter, or a combination of both, as long as it was 12 consecutive months and in a marriage-like relationship. So that's where you combine your affairs, your social, financial, family affairs, and into a marriage-like relationship. Conjugal means you've been in a marriage-like relationship for at least 1 year with exclusivity, financial and emotional interdependence, and a long-term commitment, but are prevented from living together or being married due to barriers such as laws or immigration restrictions. The conjugal partner has to be residing outside Canada. If it's possible to cohabitate or marry, then the conjugal category is not for you. To recap, spouses are legally married. Common law partners have cohabitated for a period of at least 12 consecutive months, and conjugal partners are in an exclusive interdependent relationship, but are unable to marry or cohabitate due to serious barriers like laws or immigration rules. Now to the question of inland, inside Canada, officially known as the spouse and common law partner in Canada class, or the family class, which is often referred to as outside Canada sponsorship, but actually can be used if you're residing together with your partner inside Canada. So let me help you make sense of it. In the past, choosing between the two, family class or spouse and common law in Canada, really came down to the need for a work permit and whether the person being sponsored was in Canada and needed an open work permit. But recent changes have eliminated that consideration, because if you're residing together in Canada with your spouse or common law partner and you've applied to become a permanent resident through the spouse and common law partner class or family class, you're eligible for the open work permit. So that differentiator no longer exists. Now, things like the processing time, the ability to travel out of Canada and back while the PR application is pending, and appeal considerations as well as interview considerations are really what distinguish the two. And I'm going to break those down. So if you are living together in Canada with your spouse or common law partner, you have the option to choose either the spouse and common law partner or the family class. If you're residing together outside Canada, or if one partner is outside Canada, the other is inside Canada, you'll use the family class. If you're a permanent resident sponsoring your spouse or common law partner, you must be residing together in Canada and use the spouse or common law partner class or the family class. So, how do you choose? Right now, there's not a lot of reasons why you would choose the spouse and common law in Canada class. At the moment, the family class processing time is shorter. Family class allows you to travel with greater ease because one of the requirements of the spouse and common law partner class is that you're residing together with your partner in Canada. So any travel outside the country opens up the slightest possibility of your application being compromised, because if you travel and for some reason, I mean, the chances are pretty low, but if for some reason you're not permitted entry back into Canada, you're no longer satisfying one of the fundamental and core criteria of the spouse and common law partner class, which is that you reside together. So if you're in Canada residing together and you apply in the family class, you're able to travel with greater ease and less stress or worry around what if I can't get back in. Or put another way, if something pulls you outside of Canada, say there's a family emergency or there's a work obligation that's going to take you out of Canada for weeks or a month, applying in the family class allows you that flexibility to come and go in a way that the spouse and common law partner class does not. Now, if you're residing together in Canada, a couple things to consider before you apply in the family class is that it is possible to be called for an interview at the visa office processing your application before it's finalized. So that means if you're in Canada, you could be required to present yourself in person and have to travel probably back to your home country to the visa office there where your application's being processed in order to finalize the process. So that's important to be aware of because obviously that comes with a financial cost to it. But you can weigh that against the processing time, which can be 2 or 3 times shorter using the family class versus the spouse and common law partner class. And again, the work permit, the open work permit, is available to people who have applied for permanent residence in either the spouse and common law partner class or the family class, as long as at the time of application for the work permit, you're residing together in Canada with the person who sponsored you, either your spouse or your common law partner. Okay, so we've identified the difference between spouses, common law partners, and conjugal partners, and we've differentiated between inland or spouse and common law partner class and outside or family class sponsorship categories. Now, I want to dive into evidence. I have fielded many a question about how to prove that a relationship is genuine, and for those in the common law partner class, how do you prove cohabitation? No matter what type of relationship you're in or what category, what class of application you submit, you have to prove that your relationship is genuine, that you've combined your affairs, your personal affairs, your financial, social affairs, everything is intertwined and you are in an exclusive relationship with your partner, be it married spouse, common law partner, or conjugal partner. So that's the first key. And the second piece, for common law partners, you have to prove that there's at least one period of 12 consecutive months of cohabitation. Once that period of cohabitation has been established, periods spent apart are permissible as long as you can show that the relationship continues and it is genuine. For all cases showing that the relationship is genuine and ongoing, you could include proof of ongoing communication. That might be WhatsApp chats or your FaceTime logs, emails, phone logs, showing that you're in regular communication with one another, whether you're together or apart. You can also show that you spend important holidays together, whatever those holidays might be for you, that you've attended or gone through major life events, whether it's a death in the family, a birth, anything that is important to your family, showing that you've gone through that together. So maybe you had to travel for something together, taking trips together, showing travel itineraries, booking confirmations with your name on it, photos of trips and major life events, holidays spent together. These are all really helpful things. One of the questions I get asked all the time is, for particularly common law partners, is we don't have a lease agreement with both of our names on it. We can't apply. And that's just not the case. Obviously, a lease agreement is a really easy way to show that you're in a common law relationship and that you have that period of cohabitation, but it's not the be all end all. So for example, if one person is the leaseholder and the other person perhaps moved in at a later date, you can always include a copy of the lease agreement and a letter from the landlord that confirms they're aware that the other partner moved in on X date and has been living together from that period forward. You can also, if there's no way to show proof of cohabitation through a lease or a letter from a landlord or roommate or anything like that, you could also provide documentation like joint bills if you're both on utility bills, or even if you don't have any joint bills, you probably have a cell phone, a credit card, a driver's license. You can show your individual documents with timestamps. So for example, if you provided 12 months of individual bank statements and each partner's bank statements have the same address over that 12-month period, you're able to prove that period of cohabitation. So what I always tell everyone I advise and represent is, if you're in a genuine relationship, there is a paper trail and we will find it. So just think about all the ways that you're connected and pull as much evidence as you can. You can even show your relationship status on social media. IRCC on their document checklist includes the relationship status on Facebook, for example. Photos, like I said, of major events that you've attended as a couple, vacations you've spent together, time spent with family, and include on those photos a description of who's in the photo, when did it take place, and give the context. Obviously, for married spouses, including your marriage certificate is required, and make sure it's a certificate, not the marriage license. For those partners who share children, including children's birth certificates, even if they're Canadian citizens and you're not including them in the application for sponsorship, including their birth certificates that name both parents is very helpful. As I said, if you're in a genuine relationship, there's always ways to show that you are to prove that relationship exists. You can also include letters from family and friends that can confirm their knowledge of the relationship, when they met your partner, time they've spent together with you, things that they know you've done together. For example, if they know you've gone on a big trip, or that you spend every Christmas together as a family. Those details can be really helpful. Also, if they confirm in writing that they know that you've lived together from X date to X date, or from this date to present at this address, those statements hold weight, especially, and I highly recommend that you have these letters notarized. So this is the person writing the letter taking it to someone who's able to notarize documents, whether it's a lawyer or notary public or commissioner for taking affidavits. Have that document, that letter, signed and notarized. It just adds extra weight to the letter. Now, to cover the mistakes that are most commonly lead to a refusal or cancellation of an application. Really common and most frustrating reasons is incomplete forms. So super essential to follow IRCC's document checklist and application guide to make sure each and every one of your application forms are signed properly. A bulk of the forms are online forms through the PR portal, but there are some PDF forms that you need to complete and upload. They have to be saved to PDF and then type your name. So make sure that you follow those instructions to a T so that your application doesn't get sent back to you as incomplete, because that is the most frustrating. Not including adequate financial evidence. As I said earlier, there's no minimum income requirement, but it's still necessary for the sponsor to include proof of their financial position. So if you're employed, that's the most recent T4. If you are self-employed, it's proof of your income. I also recommend just including a letter of explanation that says, here's how we support ourselves financially, and even including evidence of the person being sponsored, including evidence of their financial position. So it could be bank statements, if you have investments or savings, or if you're living off retirement funds. Just put your feet in the shoes of an immigration officer who knows nothing about you and explain your financial position and how you intend on supporting yourselves, and then add as much supporting evidence as you can. But don't go overboard. Don't include things that aren't relevant. Include only the things that you speak to in your letter. Another reason I've seen for refusal was inconsistent dates and places in the history. So the example I'm thinking of is someone who lived in one location and worked in another, and that those two places were too far to commute daily. And so IRCC refused the application, claiming that there was misrepresentation, because how could you live in one place and work in another place so far away, when in reality, this person worked remotely and they traveled to the physical office periodically, but most days they were remote. So including any nuance like that isn't clearly captured in the application forms, make sure you include a letter of explanation. In fact, including a submission letter that helps tie all the forms and documents together and tells your story is, in my opinion, essential. Because again, an immigration officer knows nothing about you, and they're trying to make a decision as quickly as they can. So helping them by presenting the application with a submission cover letter is really helpful. And in Navio HQ, you'll actually find our AI letter drafter, where I've trained the model to think like I do and tell the story like I would, include the information and details that are important and help guide an immigration officer to a positive decision. So you can use that tool, input your information and details, and generate a draft. Of course, it is a draft. It is AI, and it's not perfect. So use it as an assistant to help you draft a first pass of your letter a lot easier and faster than if you were trying to pick away at it on your own. But don't rely on it to create the final letter. An application that's lacking evidence can also be refused. Generally, an immigration officer will ask for more information, but if you're missing some of the documents that are required on the document checklist, your application might be refused without a request for more. If you've hit all the required documents, but the application is still has some holes, then an immigration officer hopefully will ask for more information. But to avoid the risk, make sure that you provide that full, well-rounded description of the relationship. Even if you're married, the marriage certificate on its own isn't sufficient. You have to prove that the relationship is genuine. And in common law and conjugal, the same is true. Common law, you have to prove the year of cohabitation. And conjugal, you have to prove that you're in an exclusive marriage-like relationship, but you're unable to be married or cohabitate due to significant barriers. So make sure that that's well documented and that you have the narrative around that clearly outlined in a letter to accompany your application. Finally, if you pick the wrong class or you have contradictory selections in your application, that can lead to a refusal or return of your application. So as a reminder, if you are a permanent resident sponsoring your spouse or common law partner, you have to be residing together in Canada. You can choose either class of application, but you have to be residing together in Canada. Only Canadian citizens can be living outside of Canada and sponsor their partner. And when you are selecting the class of application, I'm going to show you on the document checklist here. Selecting the class of application is number 5. In this example, there's a different document checklist if you're married or common law, but the class is still on there. You can see the 3 options. So spouse and common law partner, again, not a lot of reasons to pick that class right now. Processing times are longer. The appeal process is more expensive and time consuming. And both applications, both classes, qualify the principal applicant for an open work permit if you're residing together in Canada. But nonetheless, it's there. Currently living outside of Canada and applying in the family class. So in this case, you're not eligible for an open work permit unless you and your spouse begin residing together in Canada after the application is submitted. And then finally, you're currently living in Canada and applying under the family class. Of the 3 options, you have to make sure that your selection at various points in your application is consistent. When you set up your PR portal, you are prompted to select from these 3 options. You need to make sure that that matches the selection on the document checklist and anywhere else that you're asked to declare your selection. Okay, so we've covered the different types of relationships eligible for sponsorship, the classes of application, how to prove you're in a genuine relationship, and if you're common law, how to prove that period of cohabitation, common pitfalls to avoid. So, to wrap things up, key considerations when you're embarking on this journey: place of residence and your sponsor's status. This dictates whether you're applying from inside, whether you can apply from outside Canada, or if you need to apply from inside Canada. Appeals and interviews. Outside Canada can appeal to the Immigration and Refugee Board, which typically tends to be faster and less costly, versus spouse and common law partner class can only appeal to the federal court, which is more costly and more time consuming. Additionally, applying in the family class might require you to travel outside Canada to attend an interview in order for your application to be approved. Work. The person being sponsored can apply for a work permit if they're residing with their spouse or common law partner in Canada, regardless of the class of application. Travel. If you're living in Canada and you'll need to be traveling outside of Canada for work or any other reason, really, the family class makes travel easy because it's not a requirement that you're living in Canada during the process. Spouse and common law partner class applications can be jeopardized by international travel. Remember to use the link in the comments to access Navio HQ and unlock all the free tools that our experts have built at Navio over the years, and comment spouse, common law, or conjugal and your #1 evidence question, and I'll reply with a tip. It also helps us know what content to cover in future videos so that this channel continues to be as helpful and relevant for you as possible.